to welcome you to this panel. We will be discussing today how to implement international human rights law in content moderation, and especially who should do that. So we have truly amazing panelists for this conversation today. Originally, Special Rapporteur Pedro Vaca was going to join us today, but unfortunately for us, he's on an unexpected and urgent mission to Colombia with the Inter-American Commission on Human Rights. So for those of you who are eager to listen from him, I'm also sorry that he can't be here. But we have with us today Eduardo Bertoni, who has very kindly accepted our last-minute invitation and will have a lot to say about the role of regional human rights system. Eduardo is the former Special Rapporteur on Freedom of Expression of the Inter-American Commission of Human Rights at the Organization of American States. He is currently the representative of the Regional Office for South America of the Inter-American Institute of Human Rights. He was the first director of the Access of Public Information Agency in Argentina, and he was the founder and first director of the Center for Studies on Freedom of Expression and Access to Information at Palermo University in Argentina. Agustina del Campo is the director of the Center for Studies on Freedom of Expression and Access to Information. And she previously ran the Impact Litigation Project at American University, where she coordinated the research and litigation of several freedom of expression cases before the Inter-American Commission and Court on Human Rights. Jeanne Launay has recently joined the Facebook Stakeholder Engagement Team. Before that, she was Facebook's Program Manager for Human Rights and Social Good in Africa. Prior to joining Facebook, Jeanne served as Program Director for Trust Africa, a Pan-African grant-making foundation working to advance political and economic governance in Africa. And finally, David Kaye teaches law at the University of California, Irvine. He's a former UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, and he's the independent chair of the board of the GNI, of the Global Network Initiative. So let me tell you something about the format for today. Instead of having each panelist present opening remarks, we'll try to make this a bit more conversational. So I have asked the panel to answer some initial questions. You in the audience, please send us questions through the chat and I will incorporate them into our conversation. And panelists, you should also feel free to ask questions to each other. So we're here today to a great extent because of David's work during his tenure in the UN, especially David's reports to the UN proposing that social media platforms adopt international human rights law as their own default content moderation rules. David's 2018 and 2019 reports to the UN on hate speech propose that companies use international human rights law to guide their content moderation practices. Building on the work of advocates and scholars, David's work really took these ideas maybe from the margins of the conversations to the forefront of the debate about how platforms should govern speech. A big question for me in this project, and maybe for some of you as well, has always been who should carry out this task. That is, who should translate human rights standards into content moderation rules, or who can operationalize this framework. It could be that companies carry out this task. Since the Facebook Oversight Board started issuing decisions this year, it's really been the Oversight Board who has been the main institution taking on the task of adapting content moderation to human rights standards. So my first question today, maybe for David and Eduardo, is what role the UN and regional human rights organizations such as the Inter-American Commission, Inter-American Court on Human Rights can play in this endeavor? Maybe we can start with David. Is there a role for these international and regional organizations to take part in this project?
Yeah, there definitely is. And first, Brenda, thank you for organizing this great panel. It's really great to be on a panel with such great minds on these issues. You know, the UN and other international institutions have a pretty significant role here. I mean, if we're talking about companies applying human rights standards, you know, these are first and foremost standards that were developed by the international community, standards developed by states, and then the jurisprudence underlying these standards, or that took these standards forward, are basically treaty bodies, human rights courts around the world, the work of human rights experts, all over the world, really. And the role that these institutions can play is maybe twofold. On the one hand, I think what they can say is, in effect, look, individuals enjoy certain standards of rights, and around the world, these companies have such massive power mediating freedom of expression. So serving as kind of gateways in many parts of the world for the enjoyment, for the ability to exercise rights to freedom of expression, to access to information, to other rights as well. It's important to frame these rights in a way that's appropriate for the companies, and also for governments that are thinking of regulating the companies. So that's, I think, one way in which international institutions can play a significant role. The other way is something that maybe we're just starting to see, which is that international institutions can create a kind of oversight in a way. I mean, we do have the Facebook Oversight Board that is a self-regulatory mechanism for Facebook itself. But if we imagine that these are companies that have massive power, and that power is international, it's global, it's transnational, there needs to be some mechanism for oversight that is also global. And I think that international institutions can play a role in that. I don't think they can play an exclusive role, but they can certainly play a role in maybe convening and encouraging that kind of oversight.
Thank you, that's great. And maybe Eduardo can tell us more specifically about the role of regional systems. You can also talk about the global system if you want.
Thank you, Brenda, and I am very happy to be in this panel as well. And thanks for the invitation to cover my friend Pedro Vaca seat today here. He's in a very important mission. The situation in Colombia is not very good, so I'm glad that he is there seeing what's going on in Colombia. Going to the point and going to your question, I feel the obligation to start saying that we are assuming in this panel that content moderation rules are needed, okay? We are not discussing that, even though it is possible to have a discussion about that. I am, as you said, currently the representative of South America for the Inter-American Institute on Human Rights, and we participated in a hearing before the Inter-American Commission on Human Rights a few months ago, specifically on this issue. I mean, the special rapporteur opened, some sort of open consultation about the need, the framework, the characteristics, if I may say, that any kind of content moderation for social media platforms is needed. So this is something that we could discuss. But for today, or for this conversation, I am assuming that we agree that there is some need, or we need this kind of rules. So your question is about the role of intergovernmental organizations, particularly, and I agree with what my friend David just said, but I would like to add something else, which is important. In this field, it is very, very common that we request the states to have rules to regulate everything or some things, okay? Including to regulate social media platforms in this specific aspect, which is content moderation. The problem, if we have, for example, in Latin America, more than, I don't know, 15, 20 countries with different rules, that is that could be very, very complicated for the companies to comply. Imagine that you have to comply with the Argentine rules, you have to comply with the Brazilian rules, you have to comply with the Colombian rules, and so on and so forth. So that is, for me, one thing that we have to have in mind when we are planning these kind of rules. And the intergovernmental organizations can play a very big and important role there, to try to do some sort of homogenization, if that word exists in English, to extract, to get the minimum common denominator of what the countries are thinking and the academia and the social actors are thinking, and put it in one body that start a process of building what we call in law, soft law, but it could be useful for the companies to comply. Because if not, what we are going to do is to request compliance with rules that are very different, or that could be very different from one country to the other. And that is a problem. So we want to solve a problem, and we are going to create more problems. So I think that the intergovernmental organizations, the Inter-American Commission on Human Rights, the UN, have a very important role to comply here, because they are the one that can set the standards that the private sector should comply. So in my view, the role is in some way exactly what the special rapporteur at the OAS is doing right now, trying to get some, set of standards coming from the Inter-American Commission, approved by the Inter-American Commission on Human Rights, that said, hey guys, this is the path that you have to follow.
So that's great. And I have a follow-up question that you can answer, but also Agustina might want to jump in, and David as well. I'll suggest people to answer my questions, but everyone can answer them. If we want homogeneous rules, it would be, the best solution would be to leave everything to the UN level or to the global level. So what is it that regional systems can add to the project? And are there challenges in coordinating different standards that different regional systems prefer? So that's a follow-up question. I will then continue with the role of civil society and companies in this project.
May I add something there?
Of course.
To understand, your question is a very logical question, but to answer your question, we need to have a broader explanation about what the universal system is and what the regional system are. The regional systems for the protection of human rights are part of the universal system. They are not totally detached. So I think that at the end of the day, we can say, yes, it's the UN, but the regional systems are in some way also part of the UN, okay? And in some situations, it's much better to start with the regional systems and then go up. And in some other situations, it's the contrary. David did a very important job as special rapporteur for the UN, but he and my colleagues, no, they are not my colleagues anymore, and the other rapporteurs with him signed a lot of joint declarations, so it is possible to work together. I don't like this idea to detach the UN from the regional system. That could be also a problem.
Okay, great. So
do you want to take David?
Oh,
or should I?
I'll just say very quickly. So I think it's a really good question, Brenda. I think that we need to be comfortable with diversity in application. Human rights law provides standards that get applied in different kinds of contexts around the world. And I think that if we imagine that we have high-level standards that are more or less consistent globally and that provide protection and promotion for freedom of expression, but also for other rights that people are enjoying online, then we can also imagine at regional levels, those being articulated in a way that's specific to the context that's involved, whether it's political context or it is different kinds of cultural context in which in which speech is, because speech is a social thing and it's happening in different ways in different places. So I totally agree with Eduardo that we shouldn't separate these out into different elements, even though, you know, functionally there are different elements, but they're part of the same, I think, process of identifying norms and having them be applied in this, you know, relatively new space.
Just to build onto that, and I agree with everything that has been said by David and Eduardo. I think there's something in the implementation of international human rights law that is different per region, and the language of all the different regional treaties is not that different from the universal one. What differs significantly in some cases is the interpretation and the implementation, what the European Court calls the margin of appreciation, sort of, from within each system. And I think there might be different ways in which that can be included into content moderation governance from a company point of view. I think we keep focusing on the rulemaking, and maybe that's a question for the appeal system, for the prioritization of appeals, for the ways appeals are handled. Yeah, for how the actual implementation of those norms work. We kept insisting, a huge sector of civil society kept insisting on having moderators in different languages and in different places. Well, maybe, just a thought, there could be an idea to look into looking into moderators for regional systems, sort of. So that the European moderators can implement the universal standards according to European standards and can read those together, and the Latin American moderators can read the universal standards per Latin American standards all together, just like the conventions actually set out this should be done. Most conventions have language saying that nothing in this convention should be interpreted to say that the protections granted by another should be dismissed.
So I agree, and now I'm going to be a panelist for a second. I mostly agree. I think a big difference between the European and the inter-American system is in prior censorship. And so I will have questions about that for you later. But before we get too deep into that, I want to continue with the role of different actors. So Agustina, if I can bring you in again to talk a bit about the role of civil society, particularly in this idea of using international human rights law as the default content moderation rules. Does that mean that civil society should be articulating its demands in international human rights law terms? Are there normative projects that civil society has that cannot be articulated in those terms? Or is it a language that empowers the demands from civil society? And of course, civil society is it's not a homogeneous block, but you can speak to the projects that you represent.
Yeah, let me start with the last thing you were saying. Speaking of civil society is pretty hard because civil society is wide and large and very diverse and represents numerous different interests, and they are all civil society. I guess in the 9,600 and something submissions that the Oversight Board received in the Trump case, most of that is civil society. However, there are very different actors in there pursuing very different interests. What I'm seeing right now is that it's hard it seems hard for civil society to articulate in terms of international human rights. There's a number of initiatives, the Santa Clara Principles, the principles that Observacom led in Latin America, that propose an approach based on international human rights law, and an approach based primarily on freedom of expression. So the standing point for that approach is the right to freedom of expression. And therefore, that's sort of the structure that they propose. I think it's a good structure, and I think it's interesting that organizations are capturing that language. I have two caveats there. One of the caveats is I feel a part of that, of the rhetoric of civil society adopting this language can sometimes promote the idea that companies should not respect local law, but should follow international human rights law instead. And I think this is a dangerous idea. And I know I'm not making any friends with this statement, but I think it's dangerous in the sense that although we might want companies to follow human rights law, we do want them to follow local law, because bottom line, they should work as a sort of, they should work not as a unit, but at least they should coexist peacefully, because otherwise the democratic values that we have and that our laws reflect and whatnot cannot find a place in corporation governance, and that to me should not be the ideal standard. The other thing that I'm a little bit concerned about is the number of initiatives that are coming from civil society to push the human rights language, to renegotiate the human rights language and the human rights limits. I feel there's a real litigation of a lot of the concepts that the international human rights framework provides. And I think we're seeing this, for example, well, my area is freedom of expression. I feel there's a lot of that happening in what should be legitimate restrictions to the right to freedom of expression and what shouldn't be legitimate restrictions to the right to freedom of expression. I feel that's being relitigated in the conversation over content moderation and content governance.
Great, we'll get to that point again later. I want to bring in Shan to the conversation now. You work with the stakeholder engagement team, so we can build on this idea of what civil society wants from companies. I wonder how you see your work playing or not playing a role in this project. What you hear, and I'll ask a few questions, you can answer some of them. What you hear from stakeholders, does it usually overlap with international human rights law would require from content moderation, or is it different? Or do stakeholders, civil society has different expectations from companies that they have from states? And if there is a gap, what do you prioritize in developing policies at Facebook?
Brenda, and I want to echo the other panelists to thank you for organizing this panel and for giving me the opportunity to speak about Facebook stakeholder engagement work with such honorable panelists. I think as a place to start, I want to pick up on what my fellow panelists were saying about context and interpretation. Stakeholder engagement fundamentally enables Facebook to honor our human rights commitments by soliciting the widest array of feedback on the impact of our policies from stakeholders, including human rights experts, subject matter experts, civil society groups, human rights activists, journalists, and importantly, people who are affected by harmful content that can come up on our platforms. So in this perspective, our respect for human rights following UN guiding principles is by recognizing the voice and providing a platform for stakeholders to influence our content policies and even influence the way we think about harmful content. So in terms of our human rights obligations and the way that we live up to them, our engagement process can be considered a form of due diligence. So in the first hand, when we engage with stakeholders from a wide variety of perspectives, they help us identify and understand the types of risks presented by the content on our platforms and the potential negative impacts that that content can have in their lives and in their societies. And with that information, we feed that into our policy development and product development processes to mitigate and prevent those risks in an effort to secure the safety and security of our users. So I think that this echoes the concerns about context and interpretation, because just like the discussion about which legal framework should take precedence, it's about respecting the contextual experience of our users and giving them a voice in how we form and implement our policies. Also recently, we launched our human rights policy, which is a big step towards honoring our human rights commitments. And there's 3 big sub-commitments in that policy. The first one is about this due diligence and human rights disclosure reporting. The second one is around remedy, and a few people have mentioned the oversight board. That body's recommendations and decisions create an oversight over Facebook's content decisions so that it's not just us making those calls. And finally, it's about protecting a certain category of users that we recognize face unique threats on our platform. And those users are human rights defenders. So all of these mechanisms are ways in which the company uses stakeholder engagement, elevating the voices of our users to honor our commitment to respect human rights and to protect the safety of our users. I know that you're going to have follow-up questions, so I'll stop there. I can give examples later.
I do have one follow-up question for now. And we're almost halfway through the panel, so if you in the audience have questions, this is a great moment to send them our way so that we can make sure we have time for them. I guess the rest of the questions that I have for today are all trying to refine the project, and everyone knows that human rights has big areas of indeterminacy. So I'm going to try to identify some of those areas, and we can try to brainstorm how to refine what human rights standards would require from companies. So about what you were just saying, I love this idea of thinking about stakeholder engagement as human rights due diligence. And I think that's how the oversight board characterized stakeholder engagement in a recent decision. The decision, I believe you might correct me if I'm wrong, is about the case about Blackbeat and Facebook's ban on blackface. And what the board said there, if I remember correctly, is that a general prohibition on blackface would not be acceptable coming from states, but it was acceptable coming from Facebook. And partially that was because of great stakeholder engagement that Facebook did, and because the rule was sort of some kind of deference from courts to legislators when they're working well. But before you have the oversight board decision, what Facebook has is stakeholders saying, we want a general ban on blackface on Facebook. And Facebook, maybe knowing, they have a lot of human rights experts in the company, that would not be acceptable. That would not be compatible with international human rights law. So how do you go about that gap? And maybe, you can take that example or another one to try to understand how you deal with that tension at the company, and everybody else is welcome to tell us how they think Facebook should deal with that gap or tension.
And that is an example that I'd like to use, because that case, which was called the Blackbeat case, is a good example of how we put our commitments to protecting the safety of our users in practice and where those decisions and those policies come from. So since 2019, the stakeholder engagement team at Facebook interacted and consulted with over 60 global experts from civil society, human rights organizations, academics, about what harmful stereotypes could look like and how they should be treated on our platform. So in consulting on this policy, we came up with a definition for what these stereotypes could be, the factors that would help us determine when to apply the policy, and we even came up with an initial set of stereotypes. And I think it's important here to say that when we started the policy development process, we weren't calling it a harmful stereotypes policy. We were thinking of calling it a hateful stereotypes policy. And the reason we shifted was because of the feedback received from experts. And so among these 60 global experts, there was recognition that some stereotypes are particularly harmful. And why are they harmful? They're harmful when they target people based on their protected characteristics. This is about immutable characteristics like race, religion, national origin. And they're harmful when they encourage or are linked to perpetration of harms or outing of groups, which result in marginalization, violence, or exclusion. And so we know that international human rights law also mandates protections against incitement to racial hatred or religious hatred. And our definition seeks to balance those elements by targeting speech that is linked to harms against groups based on those protected characteristics. And so in the case of Black Pete, this was an application of that policy. For those who don't know, Black Pete is a tradition in the Netherlands where people wear blackface. It's a very old tradition. I think many Dutch people feel strongly that it's an important Christmas tradition, but for Black Dutch people, for Black people in the Netherlands, it's actually a very harmful practice. The board in their decision cited the fact that Black children are afraid to go to school during this period because of the fact that some people are wearing blackface, that these stereotypes result in racial discrimination, in bullying and harassment to people of color in the Netherlands. And so their decision basically validated our policy development process by saying that the harm inflicted by a widespread content about blackface in the Netherlands was more harmful than a restriction of a particular form of speech. And so I think this underscores this tension between international human rights law and our content moderation efforts. And in this case, we restricted speech in a very precise context because of the impact that that speech would have in that society. And also, I think one thing to remember is the scale at which we operate. Allowing blackface to propagate in the Netherlands would also allow those images to propagate on a platform that's seen globally. And so we can't make decisions based on a narrow interpretation. We have to make decisions about the well-being of our users on a global scale, and blackface through our policy development process was recognized as one of these really harmful and hurtful stereotypes.
Thank you. Does anybody else want to answer that question? Or okay, I have many more questions.
Yeah, it's Brenda, if I may, this is Eduardo. It's more a comment or a response to the question, but I think that something that we have to have in mind. Of course, we are living in an age in which private corporations are really powerful. I don't want to deny that private corporations can implement rules, systems, actions to censor expressions that might not be deserved to be censored. And I will go back to this idea in a moment. But wait a minute. The governments are still much more powerful than these private corporations. A government can oblige a plane to go down, land in a country, and put in jail a journalist. This is something that a private corporation cannot do, at least until now. So sometimes I scare more about regulations coming from some governments. And that's why I started my conversation saying and highlighting the importance of the intergovernmental and international organizations, the UN or the regional systems. Okay, so have this in mind. I mean, yes, they are powerful, but we have governments that are much more powerful and can, damage and violate human rights And we have to pay attention to that as well. Going to the rules that a private corporation, an entity, can implement that in some way could be a violation of our international human rights. Yes, this could happen. So I think that we are in a moment on some sort of experimentation. I say many times, that this idea of the oversight board, it's an experiment. It's something new. It should gain legitimacy. It could help. It deserves to give time to the oversight board to work. But if the rules are totally detached with human rights standards, this is something that is not going to work, and it cannot work, because we are living in a society that in some way or another, we agree to our institutional design. We agree that there are international institutions. We agree that there should be democratic elected governments that implement rules. So I am not seeing any possibility of having rules that are totally detached to international human rights standards. Of course, there could be some, some kind of interpretation in some aspects and contextualize some situations. And I agree with that. And it will be a difficult, a difficult task. But I mean, I don't want to see this conversation in a direction in which we are saying, yes, the platform's rules are totally detached to international human rights. Because if that is the case, the first one who is going to be, found guilty, if I may say, are the governments, because they are not implementing anything to stop that. So, I mean, we are in a moment that we are in the creation of something new, that the international standards play a very important role, but these experiments that we are living is something that we need. I mean, we have problems. The problems in some way are old, but the scale of the problems are new. We need to solve the problems, and we need new ideas and fresh ideas, having in mind that we already have international standards that are in place and that we need to comply.
Hey, could I?
Yeah.
Sorry, no, Brenda, I mean, you've kind of started a really rich conversation here, and I want to respond both to Eduardo's point about government power and to Jean's point about stakeholder engagement, and kind of connect those. I think it's absolutely true that governments have, like we all learned at university, they have a kind of monopoly of coercive power. That's sort of the point of the state at a certain level. And they have that kind of power that no company can really enjoy unless they're like a mercenary company or something like that. But the point here that I want to make is that there are indeed some places where the power of the companies is practically beyond the reach of governments, right? The government lacks, and this is true in many, many parts of the world, many places where Facebook, YouTube, Twitter are active, the governments simply don't have the tools, maybe apart from shutting down and blocking the platform, although even that isn't always available to a country, but they don't often have the power even to perform the kind of basic regulation that would protect their citizens. I mean, the signal example of the last 10 years was Myanmar, but we may see that happening right now in Ethiopia as well. And so I just want to caution on the issue of government power, that companies do have an extraordinary amount of power that can have off-platform consequences. But connected to that is sort of this idea of stakeholder engagement, which I think is valuable. I don't want to minimize that, but at a certain point, stakeholder engagement isn't really an appropriate or even a sufficient remedy or approach when we're dealing with these situations where companies have such massive power. And so in a place like Ethiopia, it's simply not enough to have conversations with stakeholders in the country. In a situation where you've got real potential for interethnic violence and state violence, talking to stakeholders only gets you so far. You need people who are actually doing the moderation at scale in a way that, frankly, I don't see with any company. I mean, certainly not in Ethiopia, but in many parts of the world that simply don't have the kind of market power that you might have in Germany when you get a NetzDG. And I think we need to be cautious of thinking too much about some of these processes being, acceptable approaches or even sufficient approaches when, the situation is such that we really need to see robust implementation of human rights standards, which isn't just about rules. It's also about devoting the kind of resources to make that moderation possible.
Can I assume you want to respond to that?
Yeah,
Yeah.
these are all excellent points. And I think, I'm speaking on the panel in my capacity as a Facebook employee on a team that is responsible for stakeholder engagement. And we sit on the content policy team, which is the team that writes our policies. So our work is aimed at ensuring the most fair and representative policies to address users' concerns and priorities, and to make sure that we can keep our platform safe and respect the broadest vision of freedom of expression. That said, our work is a small piece of everything that Facebook does to implement and honor human rights standards. Our community standards are informed by international human rights law. We have values that are anchored in human rights language. The oversight board has been quite explicit about the fact that it wants to push us to be more in compliance with international human rights law. And our recent, human rights policy is really a step in confirming that commitment to applying human rights standards to our work on content moderation, policy development, and products that try to mitigate the human rights impact of our services. So once again, stakeholder engagement is one piece, but I also don't want to minimize it, because I actually think, coming from, I wasn't always in the tech sector, and I think that what I love about the work that I do at Facebook is that we respect, appreciate, and elevate the voices of people who often don't even get a chance to participate in high-level dialogues on human rights. Because we speak to stakeholders who either have lived experience of the harm that we're dealing with, are engaged in some type of advocacy work, maybe not at like a regional or national level, but at a local level. And it's absolutely not a sufficient answer in and of itself. But I actually appreciate, as somebody who's been working on this in terms of the NGO sector for quite a while, that we give more voice to these stakeholders than many other processes do. And I think it's a strength, because I think it ensures that we have a deeper understanding of what our content moderation rules actually mean in practice. Of course, we can do better. And I really think it's just a complementary element to all the other work that product teams and engineers do at Facebook to limit the human rights impacts, the negative human rights impact of our platform.
So I know Tina has also something to say about this. Before I give you the word, I want to add another question about possible gaps between content moderation rules and international human rights law. And this is coming back to what we were talking before about prior censorship. So in the Inter-American system, the American Convention on Human Rights in Article 13, it's very clear that prior censorship is not allowed except for one very specific circumstance that relates to entertainment and the access of children to public entertainment. That's the only exception to prior censorship allowed on the convention. However, companies rely on filtering much more broadly than that for child sexual abuse materials, but also for alleged terrorist content. So what do you do? How do you think through that gap? Is Article 13 of the convention obsolete in the age of platforms? Should filtering be much more in compliance with Article 13? How do you think about that gap? Or should we accept that in some cases we will require from states different things that we require from corporations? So Agustina, I would love to hear your thoughts on that. And also I know you had a follow-up comment from the previous conversation.
Yeah, no, just from the previous conversation and just from hearing what David had to say about Myanmar and now Ethiopia, I'm not sure content moderation is the answer there. I think we've been looking at how content moderation impacted a situation or didn't impact a situation, or what could have been done through content moderation. But maybe we should be thinking about beyond content moderation. What should companies do in such scenarios when those things happen? Because at the end of the day, in some of those instances, you have the company weaponized by the government against its own people. It's iffy. It's really a conversation that in my mind, we should be thinking about multiple diverse potential responses, and not only a different implementation of a set of rules. I don't know. On the censorship, I've said this many times, but I'm very hesitant of speaking about private censorship when we're speaking about content moderation. I think the conversation is a little bit more complex. But the point that you made, Brenda, is really interesting. Most of the initiatives that you mentioned, the terrorist content being taken down, the European Copyright Directive that incentivizes upload filters, and now the current discussions that are underway about precisely implementing upload filters elsewhere, those are all driven by states, which in many cases are bound by an existing prohibition on prior censorship. So I think we should be paying a lot more attention to that. What are the states mandating companies to do? And how should companies react when the mandate from the state is basically what states cannot do themselves? So when you draw up a rule for someone to do what you cannot do yourself, and I think that's a way for me to think about prior censorship and about these new regulations that are coming along regarding disinformation, regarding hate speech, regarding a number of things where the regulation proposed is ambiguous. It would not even remotely pass the three-part test of legality and necessity and proportionality, but still, apparently, because states are mandating a third party to do it, then it's fine, because they're not doing it themselves. They're just delegating. They're imposing liability on another for not doing what they mandate to do. I think that's pretty important. And whether the prohibition is obsolete or not, regarding Article 13, at least, I remember an article that Don Nunciato wrote like in 2012 for the First Towards an Internet Free of Censorship, where she actually addressed this issue. And she proposed to look at this thing under two conditions. If there is due process and transparency within the company, then it shouldn't be considered as a violation of the prior constraint, restriction, or prohibition. Of course, 2013 was way before upload filters were even thought about, I think. But I think the analysis still applies. I don't like upload filters, and I really think they are incompatible with inter-American standards, particularly when they are mandated through legislation or indirect legislation like MOUs and whatnot. But I think there's a lot more to think about in that line as Facebook and other companies are automating the detection of content before anyone else can see them. And they are proud of the reports that they capture 93% or 97% of the content before anyone sees it. I think that's something to think about.
Eduardo?
Thank you, Brenda. Two things. Many years ago, I wrote an article and then I put something in one of my reports as special rapporteur, highlighting the difference between the protections of freedom of expression and the Inter-American system and the UN system. And one of the things that I focused more was this general and strong prohibition of private censorship, as you mentioned, Brenda. It's very interesting what Agustina just said. The idea of have some sort of due process for freedom of expression. In the US, there is a jurisprudence, David can help much more than me, which is the First Amendment due process. There are some cases that explain what that means. But I want to move a little bit, and I don't want to rewrite my old article. It is true that the prohibition of prior censorship is very strong in the Inter-American system. It is true also that we need to reinterpret, or interpret constantly this prohibition. But it is also true that if I ask you, Brenda, not David, what the paragraph 1 of Article 19 of ICCPR said, do you know what it said? Probably not, because people focus on the prohibition of private censorship. And I want to be misreading. Paragraph 1 said, everyone shall have the right to hold opinions without interference, period. 2, everyone shall have the right to freedom of expression. So that is very strong, very strong. Everyone have the right to hold opinions without interference. So we are focusing on the prohibition of prior censorship, and we are not focusing on this very strong provision of the ICCPR, that we can use it as well. And if I have to rewrite my article, I will focus also on this paragraph 1. This is not my idea. This is David Kaye idea. I don't know if you, Dave, can add something there, because I remember that we discussed that, and I don't remember if you finally did a report on the interpretation of that paragraph 1. But have in mind that, I mean, it's not just Article 13 that have this kind of strong provisions. Article 19 also have, and we can use it of course, that opened the door to another discussion. What is an opinion and what is not an opinion? This is a very old discussion, when we are going to draw the line between an expression and an action. You can go back to John Stuart Mill on liberty, or more recently, our contemporary philosopher, Tom Scallon. But I mean, this is another part of the conversation, but I want to remember to all of us that we also have strong provisions at the Inter-America and the universal system as well. David, I'm sure that you want to add something there. You always touch me.
No, what I really wanted to just add here was actually, it's connecting what you said to Agustina's point about thinking about these issues beyond content moderation. And, you know, if we think only about human rights as relevant to the question of what content is appropriate and what's not, like what content can be taken down or acted against and what that should just be ignored, then we're in a very, very narrow space and not really thinking about the broader impact that the platforms have, and obviously the governments have, on, you know, on freedom of expression, on access to information, on, you know, sort of the media ecosystem more generally. And so if we think about these things beyond content moderation, then yes, of course, we're thinking about the right to opinion and how, you know, recommendation systems and algorithmic amplification actually affects the way in which we consume information. Right. And it also gets us to be thinking about how and this is an opinion issue as well, how issues around private messaging that the platforms, really rely on to a significant extent, how those are also a part of, other issues that I know are on Brenda's agenda, things like hate speech, disinformation, like the whole panoply of topics that people are talking about these days. They're not just affected by thinking about content. It's also about the privacy landscape that people are operating in, the security landscape that they're operating in. So these issues are all interrelated and complicated. And to me, it means that when we're thinking about human rights being applied by the platforms, it's not just about rulemaking, it's also about human rights due diligence and impact assessment for all of the products that they introduce and all of the policy choices that they're making. And it's not always clear that the companies are doing that.
Great, so we have 4 minutes left, so I will ask you a question from someone in the audience, and you'll have 1 minute to answer and say a final word. And at 3:30, no matter who's speaking, we're gonna be shut down. So please be brief. The question is, how do we address contradictory expectations in given regions from stakeholders or different actors? Some might want to see more intervention from states, some might want to see more intervention, stricter rules from platforms, and some either might want to see more protections of freedom of expression on platforms from states or from companies. So how does this framework accommodate that conversation or that tension in normative preferences? Easy question to end.
30-second attempt. I think while I don't want to over-index on the importance of stakeholder engagement, I do think that creating platforms and spaces for different perspectives on these issues to be heard, documented, and to inform the development of policies, the development of products, and rationales for enforcement, I think that helps address this tension. And I also wanted to underscore, related to what David just said, that a lot of the decisions and policies that we develop are informed by an understanding of context. And we actually have an entire program that I manage, which is about soliciting contextual expertise from people on the ground across the world who can tell us what the impact of our platforms is really like and what the impact of the content that's on our platforms really looks like in practice. And I think creating more avenues to receive that feedback and to have it influence product and policy development is the way that we've found to date to honor those responsibilities. Thank you.
Thank you. Agustina, one final comment or word?
Yeah, I think the question resumes, basically it summarizes really nicely why we're having this conversation. If companies can adopt standards that are already have been debated, have been agreed upon, have jurisprudence, have been researched, have been developed over time, and have been democratically set up by a significant number of countries across the globe, which are international human rights standards, the closer that content moderation can get to those rules, the stronger the response may be to the conflicting interests of users, because bottom line, there will always be conflicting interests among users, and it's not an easy, there's no easy way out. But if you have a standard, and in this case, in some cases more clearly than in others, but in this case, we do have a standard. We have a standard on hate speech, not perfect, but we have a standard. Let's work on that. We have standards on a number of things. We have a test that we can apply to the rules, even if it's not the rules themselves. I think that's the whole purpose of what. Yeah, and I think it's a disclaimed purpose of the 2018 report. Protect not only the users, but also the companies from these tensions that arise.
So I think that's a great place to end. Sorry to Eduardo and David, but we're already at 3:30 p.m. So thank you everyone for tuning in. Thank you everyone for the great conversation, and see you next time. Good luck with your rest of sessions today and the rest of the week.